there's a lot of questions here, so you can ruminate on this without too much Hello. Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Raymond Sheffield, who I'm going to call Ray. Ray is an attorney specializing in trust and estates, and he has his own law firm, Sheffield Law Office, in San Jose, California. He's been a lawyer for 13 years, received a JD degree from Santa Clara University, and an LLM degree in estate planning from the University of Miami in Florida. Ray tells me he loves the role of counseling clients for their estate planning. In addition to his law practice, Ray is an adjunct professor in the Golden Gate University LLM tax program. And Ray and his wife live with their two adopted daughters, who are ages 6 and 8, who are from Russia, in Almaden Valley, San Jose, California. For this interview, we're going to be talking about handling retirement accounts, including qualified plans like profit-sharing plans and 401k plans, IRAs, and Roth accounts after a death. This is a huge area, and so there's no way we're going to cover everything. We may not even cover all the questions that I've got here. And I want to caution our viewers that we're only covering some highlights, as I said, and this is a bare starting point to learn about some issues. So we want you to get qualified tax and legal advice. Also, Ray and I are both California practitioners. We're here in San Jose, California. Some of our viewers are watching this from other places, online and so forth. You need to get advice from a local attorney related to your local rules. Okay, so with that, we'll head on. Ray, thanks for joining me.
Thanks for having me, Mike.
Okay. So before we get involved in details related to this matter of handling the retirement accounts, today is November 19th, 2013. Maybe we can talk just a little bit about some of the recent changes that are going to affect planning for retirement accounts. So I guess the first thing we'll talk about is the new 3.8% tax on net investment income. And we're not going to talk about it in detail, but Ray, maybe you can just sort of hit a highlight or two before we move on.
Well, the net investment income tax, this 3.8%, which is being used to fund the health care law. The good news is it's not, the distributions from a retirement plan are not subject to this tax.
Mm-hmm.
Right? So you don't have to pay that on the 3.8% on your retirement plan distribution. The bad news is that distribution amount is added to the other income that you have to determine whether you have to pay that tax on your other income. Mm-hmm. And so, you know, it does affect your planning, especially when you whether you withdraw and when you withdraw funds from your retirement accounts.
Right. So if you get aggressive with your withdrawals, you may just throw yourself into this tax, and surprise, you got an additional 3.8% to pay. Okay. How about the estate and gift tax exemption? Maybe you can talk a little bit about what's happened here.
Well, Congress has raised the estate tax exemption now to $5.25 million for each individual. In fact, in 2014, that's going to go up to $5.34 million for each individual. And so most people now don't have estate tax problems. Now, if you do, an IRA, a 401k, a qualified retirement plan like we're talking about is the worst asset to own. And you really should talk to your CPA or your attorney about that and plans you can do for that. But for everyone else, right, this really isn't an issue anymore. It's all about income taxes. And of course, that's why these were set up in the first place.
Mm-hmm. Okay. And how about portability? Maybe you can just comment briefly about that.
So what Congress has done now, too, is they've simplified estate planning for people that don't have taxable estates. And when you leave money directly to your spouse, like if you leave your IRA directly to your spouse, you don't use up estate tax exemption, and whatever estate tax exemption you don't use can be ported or given to your surviving spouse. So we can add her exemption to my exemption, which means, if I die first, she's going to have $10.5+ million estate tax exemption, and therefore it's even less likely that we're going to have estate taxes owed, for that.
Right. So now what's happened is that we've basically eliminated the estate tax as an issue, probably for 95% of the U.S. population, and then the other 5% are our clients.
No, so, I want to make sure, Mike, though, we mentioned this. And we're not going to talk about portability.
Yeah.
But if you had your estate plan done prior to 2011, in fact, if you had it done yesterday, because this is just so new,
yes,
every person should make sure that their estate plan is portability friendly, that it complies. Because this is a huge income tax issue. Estate plans in the past were all about estate taxes. But now it's really a lot more about income taxes. And you want to make sure that that estate plan is designed to be income tax efficient. And that probably means redoing your plan. Right. But it's very important.
Right. So, for example, a typical plan, we talk about AB trusts and so forth, we would typically have some sort of a bypass trust involved. Now, in many cases, the bypass trust is just creating additional expense and creating income tax problems, because trusts are subject to very high income tax rates under the new tax laws that have been passed. So everybody should have their estate plan reviewed. So make it your New Year's resolution for 2014 to get that taken care of. Okay, so let's move on then about these issues related to retirement accounts after a death. Aren't retirement accounts handled as part of the process of probate or trust administration?
Well, I hope not. I mean, normally when you create a 401k or an IRA, you name a beneficiary, right? Mm-hmm. And that creates a contract between you and the IRA or 401k custodian. And the money is going to get transferred to that beneficiary, avoiding probate. Mm-hmm. Now, if you don't have a living beneficiary, you probably have to probate the account, mm-hmm. right? But hopefully you don't get there, right? And that you make sure you have a living beneficiary to get that account. Unfortunately, we've had in our office a number of times where dad has named mom as the beneficiary, but never named contingent beneficiaries like the children.
Right.
So mom dies first, then dad dies, and there's no living beneficiary, and you're probating an IRA. Mm-hmm. It's good work for the lawyer, but not so good for the family.
So, and you just mentioned this, and it brought something right to the forefront because it happened with me recently, and we didn't talk about it in the planning program, and that is, even with your contingent beneficiaries, you need to think about how those are stated. So here's the bad thing that happened. My sister actually predeceased my parents. And so she was named as a beneficiary of the IRA, and my brother and my sister, and just in our individual names. We didn't have any language about successors. So since she had predeceased my parents, basically her name was removed from the list. And so everything went to, my brother and my other sister, the three surviving children. But my nephews, who are my other sister's children, didn't get anything from that account.
So that happened, those beneficiary designation forms are really crucial. And this is estate planning. It's not normally part of the estate planning process that people work through with their attorneys, especially when they're using a trust mill or something.
Yes.
But some companies use language that would have protected your nieces and nephews, but most do not. And you may not always realize it just by filling out a form and saying, okay, well, it goes to my kids when I die. And that's unfortunate. I'm sorry to hear about that.
Yeah. So I'm just saying, folks, when you're putting these together, this is something to be thought of. You really need to think carefully when you're putting these things together, especially when you've got people getting older and they have health issues, what have you. And so per stirpes is a nice little thing to put afterwards. Basically, it says to the successors, and that keeps them on the list. Okay. Why do retirement plans need to be thought about soon after the participant dies?
Well, when someone dies, things usually don't have to get done immediately, but there is a limited time to make certain decisions with regards to retirement plans. So retirement plans were designed for your retirement, not as asset accumulation vehicles for your kids.
Yeah.
And so Congress has decided that in no less than 9 months, no more than 22 months after death, you have to be ready with certain information to be able to stretch out or determine who those beneficiaries are, and so that you can begin minimum distributions.
Right.
And so they want to make sure that gets done in a timely fashion, so they put some deadlines on it. And if you miss those deadlines, there can be great penalties, not only to the IRA, but to the beneficiaries as well.
Well, I mean, you could just screw up the whole thing. So there's one other thing that we need to throw out, and that is if the participant died and hadn't, and they were over age 70 and a half, there may be a required distribution that needs to be taken for the year of death.
That's true.
Yeah.
And one of the reasons why, if you're over 70 and a half, you should not wait till the last minute to take your distribution. Because if you don't make it to the last minute, you've given your family zero time to get that done. And they may not even realize that you haven't done the distribution until it's too late.
Right.
So, I mean, we're in November 19th. If you haven't done your minimum distribution and you're over 70 and a half, call your broker today.
Okay. All right. So part of the reason why I've raised the issue about, is the administration of the accounts handled under the will or the trust has to do with who's responsible. So who is responsible for being sure that the administration of a retirement account is handled in a timely manner?
There's some confusion on that issue. It's not universal. I can tell you, so we're in Santa Clara County,
yes,
right? In Contra Costa County, right, the court has said, the trustee, for example, who handles most of the rest of the assets, has no responsibilities at all to the IRAs because those belong to beneficiaries. And so they don't want the trustee doing anything, and they're not going to reimburse the trustee for costs or expenses for investigating those assets. On the other hand, San Francisco County has said, well, these are assets of the estate, and the person who's managing the estate should at least investigate and inform beneficiaries, and they're entitled to be paid for that. I'm not aware that Santa Clara has actually dealt with that issue, in open court, but it becomes a big fight oftentimes over, trustee fees and who's responsible. As a general rule, what we tell our trustees is they should at least investigate as to whether they are the beneficiary or not, because sometimes people name the trust or the estate may be the beneficiary. And if they're not, then send a letter to everyone saying, there are these accounts, we're not the beneficiary, so you got to figure it out on your own. But ultimately, beneficiaries are the people that those accounts belong to, and that's who gets the information regarding them as well.
Right. So this is a really difficult situation because many times, of course, beneficiaries are pretty naive about these accounts. They're not well informed about how they work. And I hate to say this, but you'll find that the custodians aren't really forthcoming with information. So you go there, and it's like, you're talking to the guy, and he's not showing you the cards about this. So I think it's nice for the trustee or the executor to do it sort of as a courtesy. But like you said, there may be an issue about whether they can get paid for this, and but it's just a problem. And so again, this is one of the things that it would be very helpful for the participant, okay, the person who owned the account, to give information to the beneficiaries about in advance. And most of them, unfortunately, probably don't do that, and it makes life a lot more difficult. All right. Now I've got a retirement account, or had one, and I'm deceased. Okay, so now it's gone to. It's an inherited account now. It's going to my beneficiaries that I named. And maybe I had some contingent beneficiaries that were named. Are those contingent beneficiaries any good? Let's say that one of my beneficiaries dies after I did.
So if you died and you've now given, the money has been, the account's been transferred to the primary beneficiary.
Yes.
So it really it depends on your custodian as to whether or not they'll allow that new beneficiary to name the next generation of beneficiaries or not. If there's money in that account and no new beneficiaries have been named, those contingent beneficiaries are still going to be there. It's a complex question, and each custodian handles it differently.
Okay. Well, my understanding, anyway, in most cases, is that basically the contingent beneficiary sort of goes away.
Most of the time, that would be the case, yes.
Yeah.
And now you have it in your estate if you haven't named a new beneficiary.
Now, there are some accounts that are sort of, as I understand it, they're structured differently. This would be unusual, that it's sort of a trust account. And so if you do have it in that case, you can keep a contingent beneficiary. All right, well, how about these requirement minimum distributions now? We're talking about inherited accounts. What happens after a person dies related to these required distributions?
So, we're talking about inherited accounts, not to a spouse, as a general
let's
rule.
Let's start for the other beneficiaries, and then we'll maybe circle back to the spouse.
Right. So, by September 30th of the year following the year of death, that's your designated beneficiary date. At that time, you have to know who the beneficiary of these accounts are. And each beneficiary then, you look at their age on a IRS table. It's called the single life table. And let's say they're 22 years old. Then you look at what fraction they're required to take out of that account that year. Mm-hmm. So that, for example, that might be 1/72. So they would have to take out 1/72. And then the next year, that denominator is going to get reduced by 1 each year. So every year there's a higher percentage that comes out of that account until it's all gone. Mm-hmm. 72 is probably too high a number. Probably for a 22-year-old, it's probably more like 50, 60, something like that. Because everyone lives to about 85 on the tax table, okay, unless they're already that age. Now, that's the minimum amount. Mm-hmm. The beneficiary may be able to take more. In fact, if they're in control, they can always take it all out at once. But they have to take the minimum amount no matter what.
Mm-hmm. Okay. Now, what happens if it was a surviving spouse?
So for a surviving spouse, they have a couple more options, right? So the first option is, and the option that they're almost universally told when they call the IRA custodian is, you can do a rollover. And essentially that would mean that they now become the participant, as if they had contributed the money into the account themselves. And now we use their age, for 59 and a half for being able to withdraw funds, and their age at 70 and a half to take out, the minimum distributions and so on. Mm-hmm. They can also just stay as a beneficiary. Mm-hmm. And when they stay as a beneficiary, they can withdraw funds at any time. So they don't have to be 59 and a half. There's no penalty for withdrawing funds earlier. And they're not required to do any minimum distributions until their deceased spouse, who left them that account, would have reached age 70 and a half. So if the surviving spouse is older than the deceased spouse, there may be a strong, incentive not to do a rollover right away.
Okay.
And of course, you can do that rollover any time. You don't have to. There's no time limit on when you have to do that rollover.
Okay. So, since you talked a little bit about these choices with surviving spouse, I think we'll just go ahead and talk about the situation of, again, should they immediately roll over? What if you have a situation that you've got, let's say, the Tony Randall situation, decedent is age 80 and the surviving spouse is age 35. Should she be rolling that over to her own name?
Well, probably not right away, because if she rolls it over to her own name, right, she's under 59 and a half. So now to withdraw funds, not only does she have to pay income tax, but she's got to pay that 10% penalty. If she had just stayed the beneficiary, she would have avoided the penalty, right? And so she still has to pay the income tax, but by not having to pay the penalty, she saves herself tax, right?
Right.
Now, at some point in the future, for example, after she's 59 and a half, then doing the rollover may make sense for her, right? But she doesn't need to do that right away.
Right, so she can do it much later. Now, for you folks that messed up on this, there is another way to take the money out without having a penalty. It's called a series of substantially equal payments. So, but what it means is instead of being able to take a pretty decent amount out of the account, you may be having to take a little bit out of the account each year. And so I had somebody that came to me, let's just say it was too late. So the surviving spouse was, I believe, in her 40s, and she'd just done a rollover. This is what I call self-administration. And anyway, maybe got the recommendation from whoever was handling the account, like you said. And I said, well, it's a shame that you did that, because now this money is more or less locked into that account, and you can't take it out without having a big penalty. And, well, needless to say, she was very upset. Okay. Well, if you are the beneficiary of a retirement account, the temptation is just take the money. So why not?
Well, not only is it just take the money, it's likely oftentimes that they will take the money.
Yes.
And studies show that beneficiaries who receive $500,000 or less spend it in 18 months. So it's very common to take the money. In fact, when I teach classes to financial advisors and I ask them, how many of your clients actually are stretching out, not taking all the money right away, very few hands go up. I mean, it's just very common. Mm-hmm. The reason you don't want to take the money out is because it's all growing tax deferred.
Yes. Right?
And so it's already there. Right? It's hard to get money into an IRA. There are contribution limits to be able to get it in. So once it's in, you want to keep it in and let it keep growing, right? Because it can mean huge growth savings over time when that money's there. And, unless you're going to spend it, right, consume it, there really isn't a reason to pull it out unless the government's requiring it because of minimum distributions.
Mm-hmm. Okay. Can a beneficiary roll over an employer retirement account like a 401k account to an IRA or a Roth account?
Well, yes and no. So generally when you retire from that company or leave that company, then yes, you can do a rollover. While you're still employed at the company, you generally cannot. Okay,
well, actually those rules have been liberalized, so actually you can it's easier to do things now than
okay.
So now you can actually pull money out of accounts while you're still working there, if the employer permits it, if the plan permits it.
Yeah, I'm not aware. Yeah. So far, we haven't seen any clients that have actually the companies have modified their plans to allow it.
Okay.
Because they like keeping the money in the plans.
Yeah. They're trying to be paternalistic and make sure the employee doesn't blow it. So anyway, but the point is here, the rollover when you're doing this, it can happen after a death. It's what we call a direct transfer. So you don't take the money. It has to go directly into the account. But, I'd say the planning community was stunned when the IRS announced that it was okay to make a direct transfer from an inherited 401k account directly to a Roth account, because usually you can't roll from an IRA to a Roth, from regular IRA to a Roth after a death. You can only do it during your lifetime. So for whatever reason, they have said that this is okay, and so and the idea, of course, is that in many cases the employer can't keep the account and administer it, or they don't want to for beneficiaries, and so they're interested in getting it out of their plan, and so you need a place to park it without paying a tax. The way to do it, again, is to roll it to an IRA account. If you roll it to a Roth account, of course, now you're going to be paying tax on the entire amount that's rolled over, but you're hopefully creating then a tax-free account. You have to see whether you can afford that, because if you don't take the money, where's the money going to come from to pay the taxes?
Exactly.
Okay.
And that lump sum rollover, or that lump sum distribution, essentially, may throw you into a higher income tax bracket. So you really need to talk to a tax professional before you do that, and make sure that you understand the consequences of it.
Okay. So Ray, we just have a minute or so left. Again, maybe you'd like to just throw out a final idea or thought about these inherited accounts.
Well, I definitely think people need to treat them seriously, and don't just assume that, well, that beneficiary I named when I opened that account, or I went to work at that company, is who should be the beneficiary now. Relationships change. You may have additional children that you haven't named, as beneficiaries. You may have a different marital status than you did before. Whatever it is, you want to make sure you keep these things up to date. Mm-hmm. And if you need to also protect beneficiaries from themselves, and talk to your lawyer about whether you can leave that in trust for them, or other things that allow them not to just take all that money all at once.
Okay. Folks, we're all out of time. Hope you found this thought-provoking. See you next time on Financial Insider Weekly.